suppose the difference is between a rule that says the statute of limitations runs when the Court of Criminal Appeals renders its decision and a rule that says it doesn't begin to run until rehearing is denied. Then you're talking about a brief period of time, I would imagine, in most cases. In this instance, it seems to have dragged out. So part of your argument is that your rule is better because it serves interests of federalism and comity. But how weighty is that if you're just talking about a relatively short period of time?
So I want to make 2 points as to the additional time for rehearing, Your Honor. The first is that I think symbolically it just disrespects the state court's appellate process to say, we're not going to, the federal court doesn't care about what happens during the rehearing process. I think the second point is that, as the court knows, Section 1983 statutes of limitations are borrowed from state law. And so not every state is going to have a 2-year, 3-year, 4-year statute of limitations. I think Kentucky, Louisiana, and Tennessee, we've found, have a 1-year statute of limitations, for example. And I don't think it's all that out of the ordinary for a rehearing motion to be pending. In this case, it was 6 months for a significant amount of time. And of course, we normally don't think that someone is dilatory unless they've actually filed beyond the statute of limitations. I think the other point that I would go to is it's not clear to me what purpose the statute of limitations is really serving here for Texas. Most states, and I would point to the retired judge's amicus brief, most states don't follow the same timeliness rules with these types of post-conviction DNA testing regimes as they do for their post-conviction habeas proceedings, for example, because they recognize, I think as the court said in Osborne, like the power of DNA testing to exonerate as well as to inculpate. And so we don't have the types of concerns normally that you would have to protect with a statute of limitations, such as concerns about faded memories of witnesses or stale evidence. After all, if anything, those concerns are going to count against the prisoner.
Does the CCA grant rehearing more frequently than this court does?
I am not certain how often the CCA grants rehearing. We did find some examples where they have granted rehearing where it can take a significant amount of time for the court to do so. But I would say, going back to the earlier point, Your Honor, it would be important for the federal courts to allow the state procedures to play out because, as Gertz concedes, and I think it's page 25 of footnote 5, rehearing can change the outcome. So you would have you'd run the risk of having a prisoner run to federal court to be timely, only to have pending rehearing proceedings or the suggestion that the prisoner had to hurry up to somehow get there.